College of Engineering and
Cultural and Biosystems Engineering is designed to produce graduates who possess knowledge, skills, and attitudes in the application of engineering science, and designs of the processes and systems involved in the sustainable production, post-production, and processing of, say, food, feed, fiber, timber, and other agricultural and biological materials. The efficient utilization, conservation, and management of natural and renewable resources, and development of climate change mitigation measures. The following are the field of specializations of the Agricultural and Biosystems Engineering program. Agricultural and Biosystems Machinery and Power Engineering. Agricultural and Biosystem Structures and Environment Engineering. Agricultural and Biosystems Land and Water Resources. Agricultural and Biosystems Process Engineering. On June 2005, the College of Engineering and Information Technology, now College of Engineering and Geosciences, officially offered the Bachelor of Science in Agricultural Engineering. On 2016, the Bachelor of Science in Agricultural Engineering program was shifted to Bachelor of Science in Agricultural and Biosystems Engineering when Republic Act No. 10915 and Act strengthening, modernizing, and aligning the practice of agricultural engineering in the country into the internationally recognized practice of agricultural and biosystems engineering was passed into law, and when CMO No. 94, series of 2017 was strictly implemented. The program has then continuously advanced from traditional to the modern practice of agricultural and biosystems engineering. The Bachelor of Science in Agricultural and Biosystems Engineering program is a 4-year curriculum which was designed to develop agricultural and biosystems engineers who are uniquely qualified to use their knowledge in mathematics, biological and physical sciences, and engineering principles. The said curriculum is categorized into technical and non-technical courses. The technical category are those courses involving mathematics, natural sciences, and professional courses, while the non-technical category covers the general education, NSTP, and physical education courses. The Agricultural and Biosystems Engineering also has a strong program educational objectives that are in line with the university's mission and vision to become globally competitive and sound professionals. In 3 to 5 years after graduation, agricultural and biosystems engineering graduates are expected to provide leadership in planning, implementing, and monitoring ABE projects and programs, occupy supervisory positions in private and public organizations, locally and internationally, own and/or manage ABE-based business enterprises, pursue advanced studies in ABE and emerging related fields, and occupy responsible positions in ABE education. The college's competent faculty and staff and with the aid of a wide range of modern equipment and facilities, allow the students to attain core ABE competencies, useful for the comprehensive practice of the profession, such as the solving problems related to the production, handling and processing of biological materials for food, feed, fiber, and fuel, preserving the natural resources and environment quality, and the design and production of machine systems. In order to attain the learning outcomes of the students and ensure the delivery of quality education, the ABE program of Caraga State University utilizes state-of-the-art equipment, laboratories, research centers, and other facilities to aid the learning process of the students. During enrollment, the BS ABE program prioritizes the admission of those with high entrance examination scores and exemplary performance during high school, particularly in mathematics and natural sciences. Since 2005, the number of students taking up Bachelor of Science in Agricultural and Biosystems Engineering in Caraga State University has significantly increased, resulting to the corresponding increase of Agricultural and Biosystems Engineering graduates per year. From 2005 to 2020, the Bachelor of Science in Agricultural and Biosystems Engineering program has produced a total of 114 graduates. The percentages of students who graduated on time were relatively low for 2014 to 2016. However, in 2017, a significant increase to 60% was achieved. Now, the Bachelor of Science in Agricultural and Biosystems Engineering is considered as one of the most promising and preferred degree programs in Caraga State University. In order to improve the students' knowledge, abilities, and skills, most particularly in developing their professional attitude, the program highlighted the importance of instructional materials or any other educational resources to contribute to their overall upbringing. To prepare the students on the actual real field of work and possible career challenges, the students are required to undergo a 360-hour on-the-job training as part of the ABE curriculum, in which the students were sent to government agencies, private firms, factories, processing plants, and research institutions. It aims to let the students experience real-life scenarios in most workplaces in their chosen field. The Bachelor of Science in Agricultural and Biosystems Engineering faculty and students in Caraga State University have received several awards and recognitions in the local, national, and even international levels. Some of the faculty members are recipients of the Best Paper Awards and Special Awards due to their dedication in teaching and research. The Agricultural and Biosystems Engineering faculty members and students are also active in their respective professional organizations, with regular participation in the various activities and forums.
I always believe in the potential of the agricultural sector. So that's probably why I decided to pursue agricultural and biosystems engineering. So along with it, CSU became my option because basically CSU is one of the prominent agricultural schools in Mindanao. Agriculture is one of the key sectors that provides a lot of opportunities for different people. And I think I would really love to recommend the faculty were so supportive. They allowed me to actually realize my potential there. I've met so many amazing people also, and they became my mentors until now, and I'm so happy because it gave a lot of opportunities for me yet again. And also in Malaysia, I went there last 2019, and we won several awards, and that include the Gold Medal Award and and also the special award for the most new technology, which amazes me because for a simple study to be so well recognized and well awarded.
I am very thankful because of agricultural and biosystems engineering, I was able to participate in an international field force training in Philapacorn University, Thailand. Because of this training, I was able to learn about dyes, horticulture, solar drying, and its application to their community. This is a very good opportunity for the students who are taking up agricultural and biosystems engineering for additional knowledge from other countries. In participating in this kind of training courses, this will help and guide the students to innovate and develop in the field of agriculture and hopefully will be applied in our country.
Based on the recent Tracer study conducted by the university, the Agricultural and Biosystem Engineering is one of the top 3 programs with the highest employment rate of up to 90%. The Agricultural and Biosystem Engineering graduate are receiving an average salary of more than 25,000 pesos. Most of Agricultural and Biosystems Engineering graduates are employed in the government agencies, such as Department of Agriculture and its Bureau, Department of Education, DENR, LGUs, and other private firms and industries.
Good day. By the way, I am Engineer John Weven Itingas, a licensed agricultural and biosystems engineer from Caracas State University. Then I am currently working as an agricultural engineer here at the Office of the City Agriculturist of the local government unit of Butuan. As in line with my work experience, the best program na i-share sa akin ng Caracas State University is, I think, the farm mechanization. In farm mechanization, there are 2 factors na pwede kong i-share. First is, in farm mechanization, pwedeng mag-increase yung farm productivity. We are in line sa aming work na i-help yung mga farmers to improve or to produce more yield. That is why we are encouraging them na magamit ng mga farm machineries and equipments.
From 2010 to 2019, a total of 140 licensed agricultural and biosystems engineers was produced by the program with 2 top notches recorded. Top 3 in year 2011 and top 7 in year 2018. The program also recorded a consecutive 100 passing rate in the 2010 and 2011 licensure exams given by the Professional Regulation Commission. Moreover, the performance of the CSU, Agricultural and Biosystems Engineering, in the licensure exam is consistently above higher than the national passing score from 2010 to 2019.
I am Art Imdalman. I graduated and passed the licensure examination year 2018, and now I am currently working as Science Research Analyst at the Philippine Center for Post-Harvest Development and Mechanization, also known as PhilMech, under the Rice Competitiveness Enhancement Fund Mechanization Program. For me, I guess the best thing or secret is just to strengthen your relationship with God. Not only on exam days, but every day. Before you open your notes to study, ask for His guidance, knowledge, and wisdom for you to understand the lessons or topic you are going to study. The same thing goes after you study. Pray to God to help you remember you have studied. And also, you need to practice what you have learned, because board exam is not always a battle of IQs only, but also of hard work and perseverance.
The faculty members and students are actively engaged in the different research and innovation conducted by the program for the last 5 years, some of which were recognized in the local, national, and international fora.
And the BS in Agricultural and Biosystems Engineering program of the Caracas State University has contributed a lot in the research and development of the university. In fact, the PLIDAR tool, which is about resource assessment, has contributed a lot of publications, particularly in the year 2016, 2017, and 2018. And the innovations made by the faculty.
I am Jeffrey Tidaliosa, the Director of the Technology Transfer and Licensing Office of Caraga State University. And I'll be happy to share the progress that we've made with the BS Agriculture and Biosystems Engineering, or the BS ABE program of the university. So, speaking about technology development innovation activities, the ABE program has led the way, in terms of the development R&D of agricultural machineries, and actually this has been applied with different protection, patent, and utility model, and we've seen the impact that it has done in the lives of members of our communities, especially our farmers.
Good day, everyone. I am Engineer Al Abduhan, one of the faculty members of the Department of Agricultural and Biosystems Engineering and a current Research Center Director of the Center for Resource Assessment, Analytics and Emerging Technologies, or CREATE. The Center for Resource Assessment, Analytics and Emerging Technologies, or CREATE, is one of the research and development and innovation center in Caraga State University. The center is committed to make the Caraga region's resources and agricultural landscape the platform for research and development in the integrated fields of agricultural and biosystems engineering, high-performance computing, and other emerging technologies towards an aesthetic-based resource management and sustainability.
As part of the university's main goals, which is to actively engage in extension services, the Bachelor of Science in Agricultural and Biosystems Engineering program is also taking initiatives and programs that will answer the socioeconomic, technical, legal, and other basic needs of the community. Hence, several extension activities and initiatives are conducted by the program together with its partner organizations and the mutual support from the university. At present, there are 2 active extension projects that the Department of Agricultural and Biosystem Engineering is undertaken and monitored. These are the
Ako dahil si Bobby Barrios, a former student from Caraga State University, and I am the researcher of the study which is entitled Integrated Rice Tilling System. Ang Integrated Rice Tilling System, akong gilisan ang tilling wheel sa floating tiller. Then gi-combine ako ang tilling blade sa rotivator para mas ma-properly cut, then properly till ang soil for rice field. Nakita na ko na problema sa existing floating tiller kay dili niya ma-properly cut ang rice straw, stubbles, and also the weeds. Then di po niya ma-properly cultivate ang soil sa rice field. Then di po niya ma-attain ang depth nga required sa rice field.
Since 2005, the Bachelor of Science in Agricultural and Biosystems Engineering program of Caraga State University has showed promising and exemplary undertakings in the area of instruction, research, and extension in line with the mission, vision, and goals of the university. The Bachelor of Science in Agricultural and Biosystems Engineering program will continue to uphold the core values of Caraga State University, will aim higher and better for the continued success of the program, the college, and the university. Agricultural and Biosystems Engineering for Life, Bugsay pa more!
of webinar series. So how are you everyone? We are acknowledging the presence of one of our resource speaker. Hello, Engineer Jeffrey. Hello,
Hi, good afternoon.
Engineer Sanchez. Hello, sir. And hello, Professor Kenneth. Hello, sir. And to Engineer Grana. Hello, sir. Good afternoon. Welcome to our listener series for today's endeavor. So I hope you are doing great. So yesterday, three distinguished speakers who have shown leadership excellence in the field related to their topic, that they able to share their ideas about intellectual property rights, its forms, significance, and the role in technology transfer. The previous session was composed of 3 parts with 3 different distinguished speakers. So I hope, guys, that you still remember all the learnings that you have gained yesterday. So at first, the intellectual property was discussed roughly as said that intellectual property refers to creation of mind, inventions, literary and music works, and symbols, names, images, and designs used in commerce. Furthermore, intellectual property rights, or IPR, was discussed also, and as mentioned, intellectual property gives an owner the right to exclude others from commercial exploitation. It gives the owner a right to allow a prohibit someone to use or commercialize their property. So with that, I know that everyone now can effectively differentiate the IP, or the intellectual property, and the IPR, or intellectual property right. So I hope, guys, that you'll bear with us along this program, because there might be some technical errors and unnecessary background noises. So the overview on the basic intellectual property rights was then discussed by our second resource speaker. So Professor Kenneth discussed types of IPR and also the penalties for violation and right. So there are also various of types of property was also discussed by Professor Kenneth. So such as the movable property, immobile, and intellectual property. So different types of intellectual property with their corresponding validity was also covered, such as patent, industrial design, utility models, layout designs, protection of undisclosed information, trade secret, trademarks, and others. So with this, I know that everyone can now successfully distinguish the different types of IP. So requirements for the patentability was then discussed by Engineer Grana. So at the last part of yesterday's endeavor, the topic was very interesting, right? So because we were given a chance to educate ourselves in terms of those kind of knowledge that we have gained yesterday. So patentable and non-patentable inventions were discussed also. So anything that is contrary to public order or morality is considered as non-patentable. So moreover, in order to meet the patentability requirements, or one shall meet 3 main requirements, mainly ability and inventiveness and industrial applicability under the RA 8293. So it means that failure to meet these 3 requirements will lead to a cancellation of patent grant. So as a future engineers with innovative skills and critical skills that we have, those knowledge that we have gained yesterday will be a great avenue for us to grow as an individual. So I hope, guys, that you are ready now to learn and to listen, that because I know that our resource speakers again really prepared for this day, because this is our last day, guys. So let us keep hanging there, because now is the last day and I know that we will learn a lot today. So please stand by, everyone, because few minutes we're going to start our program. would like to thank you to all participants all over from the Philippines, especially prestigious universities across the country, such as Caraga State University, Surigao del Sur State University, Central Luzon State University, Cagayan State University, Bohol Island State University, Pampanga Agricultural State University, Visayas State University, Central Bicol State University of Agriculture, University of the Philippines, Los Baños, Don Mariano Marcos Memorial State University, and Mindanao State University, Maguindanao Campus. Hi everyone, and welcome to for today's webinar series. So I hope that you're still there with us, and let us stretch our bodies and able to wake up the research enthusiast spirits within ourselves. So welcome everyone, and thank you for joining us again. How are you once again, everyone? I hope that you are doing fine. So we really appreciate for your presence to all of our participants, because I know that some of you guys are really fighting alone in your silent battles. So we hope that you are going to enjoy and bear with us today. So to formally start our program, let us bow our heads and feel the presence of God through our virtual invocation, to be followed by singing of national anthem through visual presentation. Please stand by.
Under your wings, cover me within your mighty hand. When the oceans rise and thunders roar, I will soar with you above the storm. Father, you are king over the flood, and I will be still and know you are God. For rest my soul in Christ alone. Know His love in quietness and trust. When the oceans rise and thunders roar, I will soar with you above the storm. Father, you are king over the flood, and I will be still and know you are God. I will be still and know you are God. I will be still and know you are God.
Mga kababayan, ang pambansang awit ng Pilipinas.
Kayang magiliw, telas ng sinakalan, alam ng puso sa dikit
All right. Good afternoon once again, everyone. So this afternoon is a long way again to a lifelong learning opportunity to learn more about research. So this is a continuation of our webinar series. So I hope that you will bear with us to whatever technical errors that we have along this presentation or this program. So I believe that our resource speakers are already ready, and I hope also to our participants that you are also ready for this last day of our webinar series. So in this webinar series, you will get one certificate right after this program, after evaluating or answering our evaluation form given later. So if you have questions, we will glad to accommodate it all after each speakers. So, and I hope that you will bear with us. So now, allow me to introduce myself again. I am Kenneth Sindol, a third-year student taking up Bachelor of Science in Agricultural and Biosystems Engineering in Caraga State University. And I will be your virtual MC again for the third time today. So I hope that you will bear with us again. And we are really happy to see you and to see you for joining us again today, because this is our last day and we should cherish this day. And now let's move to another part of the program, because I believe that the people behind this event and also to our speakers are really prepared and excited to showcase and to share with you of what we have got. So at this juncture, help me welcome again for their opening message. Let us hear from our PS ABE representative and also the current League of Campus Teacher, Ms. Hannibet Arroganza. A round of applause, please.
To our excellent and supportive ABE Department Chairperson, Engineer Philip Donald Sanchez, to our praiseworthy guest speakers, the Director of SETU's Innovation and Technology Support Office, Engineer Jeffrey De Losa, Sir, to the technical experts of CSU ETSO, Sir Kenneth Shadad and Sir Lawrence Grana, welcome, sir, to the directors, deans, and faculty of SASU, to the committee behind this webinar, fellow students and guests, a pleasant afternoon to every one of us. It is my pleasure to welcome each of you in the second part of our ABE 197 webinar series. This two-day virtual event covers the lectures on intellectual property rights and the basics of patent search, drafting, and application process. These lectures are relevant for us as engineers and pioneers of the future, for this will usher to the world of technological advancement. Our world will not be what it is today without innovation. As Bill Gates stated that innovation is the most powerful force for change in the world, fundamentally shifts the trajectory of development. So please bear with us as we go through this webinar series. We are hoping that you will gain significant insights, and may this webinar ignite the flame of creativity in you as future innovators. Welcome once again, and thank you for joining us in this virtual event.
Thank you so much, Beth. Indeed, that it was always and always a warm welcome for all of us. Thank you so much, Beth. And may request also to our participants to please double check your mic and please turn it off, because we are going to start now in our first speakers. And we also hoping for your understanding and consideration. So I hope that we're on the same page, because again, the people behind this event are really excited right now in our last day of today's webinar series. And I know, guys, that we already introduced to you about our speakers in their endeavors. We already introduced to you yesterday, and I know that you're really familiar with them. And now to help me welcome for our first session, our first speaker, help me welcome again Engineer Jeffrey T. Deliosa. A round of applause, please. Hi, sir. Good afternoon.
Hi, good afternoon. Thank you, Kenneth. Good afternoon, everyone. Good afternoon to our Department of ABE chairperson, si Sir Philip, who is also here. So also our fellow colleagues in the Titilo Itzo, Kenneth and Lawrence. I think they're here already. Yeah, to everyone who are here back in this webinar, thank you guys. So it's already 1:29. No? So I think we started the same time as also yesterday. So I'll try to limit our talk now. So we've extended a lot of time yesterday. So we'll try to limit our discussions to an hour. No? So yeah, so to discuss and present to you the really the main topics, no, or the highlights of the things that we need to discuss this afternoon. So on my clock, it's already 1:29. So I'll just try to give myself an hour, not to respect your time as well, not so that will not extend this webinar this afternoon. All right, can you please stop share for now? All right, so that I can share. Are you guys ready for a Kahoot? So we'll skip the Kahoot game now. So congratulations to the winner yesterday. So let me proceed with the presentations prepared for this afternoon. So basically, I'll discuss the basics of the overview of the patent information search. So when I feel like I have a very low internet connection or slow internet connection, I'll just try to turn off my video. So I'm quite also disturbed. I would like to request also my co-hosts not to admit those who are trying to get in the webinar. No? So I kind of distracted sometimes. All right. So 1 hour. Hopefully we'll be finished by 2:30. I'll try to do this as fast as I can. Try to discuss the important things. All right. So we will talk about overview of patent information search. So the presentation outline, we will cover what is patent information, why conduct patent search, and what are the objectives of patent search. And finally, it's a bit long here, types of patent search. All right. So as not to disturb us, I would like to request also everyone to mute your microphone as we proceed with the discussion and presentation. Thank you for turning or off your microphone. No? All right. So let's start. So our references, basically, the presentations I have prepared today are from the World Intellectual Property Office, no, and US Patent and Trademark Office. I think we need to make mention with them now, and we have prior approval, especially with WIPO, not to use their materials. Unsa to? So we have prior permission with WIPO not to use the materials that they have. So basically, sorry, I get distracted for those who are not yet muted. So okay, so the references include also the US Patent and Trademark Office, because that's where the patent information also is coming from. So I think we still have participants who are not muted. Can you help me guys check who they are? We need to turn off their mic, no, so not to disturb also, and let us respect also the other listeners, no. All right, so yeah, also a word of advice, no, every time we make presentations, we need to highlight the sources of our information, no? So include there, and basically we need to also like seek permission, no, to use their materials, no, if ever we need to, so but basically the information contained here, so this is tailor fitted also now to what we are trying to discuss this afternoon. So basically I compiled this based on the information coming from WIPO. Right, so I don't put copyright notices, no, but then mainly because the content is also coming from WIPO. All right, so let's proceed with the introduction to patent search. So so patent information, so there are differences among countries on how patent application is treated. Once we lodge our patent application at any given government office that would receive those applications. For example, here in the Philippines, once again, we have the Intellectual Property Office of the Philippines that receives our patent application. So we have this different format, different document style of documents. We have different forms now in different countries. So this afternoon, we will focus on the common information that can be found in the patent documents once they are actually published. So basically, there's this process when we apply for patent application. After 18 months, the patent application document is also published. Yeah. Please turn off your mic na lang, no, please. And then in order to be granted a patent, any patent applicant starts with filing an application containing information on the patent specification, which is submitted to the receiving office to request for a patent right. So we start here. So we start with the patent documents applications that we apply in the IPO field. So the application document contains all the information described the patent. So there's that thing I think that we discussed yesterday, that in exchange for getting a patent, we need to disclose everything about the technology, such that the grant of IP or patent for that matter can be provided. So the description, I mean, all the information in the patent application that fully describes about the technology or patent that we wish to get. So the patent document has the following distinct informations as well. So there are 4 items here. So it provides details of the invention, including information on how the reader could carry out the invention. So if you look at the patent documents, there's full description. So there's specifications there, details about the invention, drawings, and how you would actually carry out the same invention. So as to like you can actually not reverse engineer, but actually you can demonstrate that you can build that invention based on the information provided in the patent document. It describes the invention claim in essence, identifying the legal scope of the patent right, and I think we will be discussing about claims. So referring to the legal scope of the patent right. Of course, we've discussed about yesterday companies that fighting one another about their patents. So meaning to say those companies, the respective companies have a legal right of their own to like claim over the other company. Also, the patent document identifies the inventor and the patent owner, which are sometimes different entities, and any other legal information of the owner or the inventor. So the document also provides references to other patents or documents if they are relevant to the invention. So that means that patent documents are the same way as journal articles. So in a way, because patent documents also refer to other prior art or other documents that are relevant to the technology that we are trying to apply for. Okay, so the published patent document is often organized in a uniform manner, and the front page of a published patent application basically provides information, provides bibliographic information such as, the title of the invention. These are the information you can get from a patent document. The date of filing, so when does the application was filed. The priority date, or the date that the content of the application was first filed in any country or region. So for example, here in the Philippines, because we are nationals of the Philippines, so basically that's where like we go to our local country first. There was a question yesterday, I remember, no? So kinsa day dapat mag-apply, no? So along that line. So basically, mga citizens of the Philippines can apply, no? But other citizens outside the country can also apply, and the condition is that dapat na sila business entity here in the Philippines, no? So ingon na siya. So it is being allowed, no? So for example, we have so many companies who are based in semiconductor companies or electronics industries or companies here in the Philippines, and basically there are researchers, you know, who are based in Europe, in England. I have that case before while I was working in Philips, that we've filed for patent application jointly. There's a Filipino and there's a foreigner that is included as part of the inventor. So the relevant technical field is also included. So for example, for you guys, agricultural machineries, no? So agriculture equipment, for example, like that, no? So in our field, we are into the field of electronics. So the name and address of applicant is also indicated, and the details of the inventors. So I think this was covered yesterday in the patent. When we apply for patent, it may not be that if we are the inventor, it may not be that we are also the owner, no? So just like the case in CSU, if you're the researcher, doesn't follow all the time that you're the owner in the invention. You will be considered as inventor, but the owner of the invention, because we have our IP policy, the university will own the IP. No? So the ownership belongs to the university, but the inventor, you will be identified as the inventors. So it's just the same manner when we are in the company. So in our company before, so we work there, we are employees, and then we develop technologies, we develop new package, no? So semiconductor package. When we apply for patent, the patent application ownership belongs to the company. Now, for example, Philips Semiconductors, and then of course you will be identified as part of the inventor, no? So application. So this is an example of a patent document. So I think I hope it's not the first time, but if it's your first time to see a patent document, this is the front page. No? So you have here a patent document. A lot of details given here. So I'll just check it. So this is the name of the invention. No? So it's beer barella. So you'll see what is this beer barella. No? So I kind of chose this because I remember during our patent search training before, I think in 2016, if not, yeah, so in 2016 that the beer barella was given an example. No? And then you'll see that this is the application. I mean the name of the invention. And then the inventors are actually identified here in bold capital or in bold letters, no? And then you have their address there also. And then the invention actually was filed in October 19, 2001. So this is almost 20 years, no? So we are now in July. So somebody said yesterday, also asked, can you copy the same? No? So if I'm not an inventor of this technology, you can actually like use this invention and then commercialize it. So there's that one question yesterday. So you're free actually, no? So to commercialize, especially if the invention is already expired or the invention is not applied or protected here in the Philippines. So to answer that question yesterday, so there are two cases, no? Kung if even if you're not the owner of the invention, you can commercialize it. And then the third is the date of the patent, which is approved, no? So this is an approved patent, October 28, 2003. The patent number issued to him is US 6637447. The B2, their extension is an approved patent, no? So B2, that is the suffix. And then when you see documents that ends with A1, A2, that means that that document or the invention is still undergoing process, no? So for approval. All right. So these are the classification also that you can see here. So later on, my colleague will discuss to you in detail, no, about what is patent classification. So you see the numbers there. So INT.CL, that is international classification, you see A45B 1100. So these are codes now that will be explained to you later on. Okay. All right. So nauna ang drawing. So the patent document also contains an abstract and a representative drawing of the invention if available. So you'll see here, guys, that we have this abstract here given. No, so abstract. So in the first page of the document, you will see that often. Okay, I'll just, okay. So what else? You have information here locating, retrieving other related documents. So these are documents, related documents that you can see. So reference cited here. So based on this invention. So it's just like a journal article. Okay, next slide. We have patent specification. So the most important informative part of the published patent document respect of the substantive aspect of the invention is called the patent specification. So this is where you really get the information that are being disclosed by the patent agent. Now, of course, the inventor may not be the same as the patent agent. So usually the person who wrote or write the patent application document is called the patent agent, and the patent agent put everything in order, follow the guidelines of the Intellectual Property Office of the Philippines in terms of the document. Julie, can you turn off your microphone, mute yourself? All right, so a specification of the invention includes the background of the invention. All right, it also includes the summary of invention, the brief description of any drawings, and the detailed description of the invention. So siguro para it would help you guys, I will share a document that will allow you to understand better. Okay, naka-PowerPoint man na siya. So I'll just look at the, yeah, so this document that I was talking about earlier, it's about the beer brella. So if you use Google Patents, actually you can find documents now using Google Patents, like patents.google.com, and then you try to search for the document you wish to find. But since I'm very familiar already with beer brella, I just use Google patents.google and then search beer brella, because I'm familiar with this already before. Now, so this is the basic, pinakadali na patent database or patent search you can find sa platform. So this is a document about the beer brella. Okay. So you can have here so similar number. So actually you can download the PDF file or you can open it. Let me see if I can move it. So there's so many people pa coming in. Good afternoon, everyone. Magsigil na kog admit ani. All right. So if I click that, okay, let's see. So this is the patent document now. I hope you can see the patent document. Makitaan ba ninyo? Can you thumbs up? Makitaan ninyo ang document? All right. All right. Thank you for confirming. Makita ninyo ang document. All right. This is an example. So we mentioned about the front page as the bibliographic page. Information you can find. So you see the inventor's name, the type of the invention, then the abstract, the drawing. And now we mentioned about the specifications. So because of also the thing that we mentioned, the drawing. So these are the drawings that the patent agent kind of displayed, so as to help the descriptive part of the patent application. So na yung mga drawings to assist. And I think you guys as ABE students, you know how to write or to make drawings. So details. So we expect, actually every time we file patent applications, so we enforce that by drawing because that would help us visualize. No? So anybody who will see these drawings can replicate, no, can actually recreate, no, the invention. So that's the primary purpose of the information, the patent documents that we provide to the hypophile. And in return of this full disclosure of the invention, so the examiner will have a better time understanding the invention that applied. No, pag ngayuna na gani ang kuan situation that is easier for them to understand and follow. So I think easier, no. So mas dali na lang siya. Mas dali siya sabton sa examiner. So dili siya mag-comment nga na yung mga problema sa sa mga even the smallest type like grammar error or something like that. So we talk about the specifications and we mentioned about first you can find here the field of the invention. So what is this invention related to? So this is a accessory for use with beverages. And then what you have here is the background of invention. No? So I hope makita ninyo sa inyong cellphone if you're using the cell phone. So really thoroughly describing what the invention is all about. No? And then you have the summary of the invention. And then what you have also here is the description of the drawings or brief description of the drawings. So basically the format what in the US Patent Office, we also have the same. So we also provide this information. And then we also provide the details of the detailed description of the invention. Okay, so you can find it here. No, so ang aning a document. No, so this is a short document, and there are patent documents that are very, very long depending on the technology. So very short lang siya. This is a good one, 8 pages. No, so not too long, not too short. No, enough to describe the invention. All right, we go back to the PowerPoint file. Of course, no, so baliktad dere, and we are actually in the patent specifications. And then another important thing is that we refer to the claims. No, when we later on there will be like mga prosecution. Now there will be like we mentioned about the patent wars. So basically, in the claims, so defines the scope of the legal protection. So remember this claims, ha. So magkwanta. If you have time later, we will have our Kahoot game again. No? So to cover what we have discussed this afternoon, from me to Kenneth to Lawrence, no, and then we'll have a Kahoot game afterwards, siguro, no, if we have time. So I hope you're okay with that. So while drafting claims, the applicant will draft them as broadly as possible. So that's the technique of the patent agent, no, so that we'll be able not to like will not limit us to like to the legal part of protection, no? So as broad as possible, but basically the story is that the IP office, the examiners would also have a different view. They would want it to narrow the claims, no, to the actual invention described in the specification. So kung makalusot, okay, no? So in terms of claiming a broad claim. And I think this was discussed also during the last talk yesterday with Lawrence, now about the claims. So in patent litigation, interpreting the claims aspect of the patent document is the first step in determining whether the patent is valid and whether the patent has been infringed. Now, so basically, if we have two companies now, just like what we have discussed yesterday, Apple and Samsung, they go for litigation. No? So they go to the court, no? To the US court or the South Korea court, or what is the name of the court in South Korea. Like they move from the local, regional to the state court, and then they go to the Supreme Court because that's where really the final decision will be made, no? And mga sa Supreme Court. So they would look into these claims that you define, no? Or the patent agent define in terms of what you claim and what you don't have. Now, so for example, basically, I'm not sure if that was mentioned yesterday. The claims part kung nakay balay, nakayuta, no? So nakayuta, basically we claim the part wherein nga naatay legal nga kanang claim, no? For example, sa muhon tumuhon, di ba? Sabot man siguro magmuhon, no? Una, ang atong yuta sa atong balay, kung asa nakatukod atong balay. So before ta nagpalit na naman na yung mga muhon, no, to determine nga that is the part of our property, no? So within that sa suludan ng muhon mao na to ano. So beyond that dili na to tagiya, no? So claims are like that, no? So meaning to say we claim ownership to those kanang area, no, nga naatay katungod kumbaga, no? So that is a claim. Ingana pod ang claim sa patent, no? So if we develop a machine, so we set boundaries, no, as to the ownership that we think that we have claim over, no? So natay katungod bale. All right? So sa patent document, we always highlight that, no? So sa US patent document, so we claim, no? So mao ni yang gipang claim karon, no? So there sa patent drafting ng webinar, this is where we deep dive as well, no? So in patent search we don't talk a lot about this yet, no? So we claim, no? So but then we're talking about patent information, that's why we're also looking at this. So these are the claims, meaning to say we are setting boundaries of ownership to our technology. Okay. So where is patent information can be found? So long time ago, long time ago, in the 1800s, believe it or not, so believe na lang, in the 18th or in the 17th century, 19th century, no? So in the 19th century, so patent already existed, no? So that means that people are working already in patent office, no? And this was in the time before the internet. Kana sa ramugutan ng internet. Now, so people, when they do patent search, no, so when they look for patent information to see to it that to determine nga naana by invention ngayon nanin, no, so there is a physical search of patent information contained in abridgment of patent documents was conducted. No, so this was followed by closer look, page by page, copies of some original patent specifications. So imagine yourself going through all the papers, no, so if you cannot find a document, there is in some countries the physical search required travel to a specific or special office to gain access to information. So for us to do that. So yeah. So do you know, guys, so if this is 1860, no, based on the description, this is in 1860 to 1870. And do you know, I'm not sure if this was touched yesterday, what is the first patent that was approved by the Philippine Patent Office? Do you know? It is not a machine, no? It is not a machine, but a process, no? A process of extracting oleaginous oil from seeds and nuts. So that's where around 1950s. So 1950s, that's the first patent granted in the Philippines. But here you see they're already working with patent documents now in 1860, 1870. And another trivia is that our grandfather, atong grandfather, no, si Albert Einstein, actually he worked with the Swiss Patent Office. No? So in 1905, no, circa 1905. So he's a guy who reviewed patent documents because he is part of the office, no, the Swiss Patent Office. He was a patent clerk there. No, so he also like if the way we work today, no, so he's a patent clerk reviewing patent applications documents, no, in 1905. So there was this theory that perhaps the pagka-genius ni Albert Einstein was actually like molded, no, because of the time he spent in the patent office. No, so yeah, that's why after this stint with the Swiss Patent Office, actually that's where he developed a lot of theories, no, the theory of relativity as we are familiar with. Actually, I just included there. Go ahead, say patent clerk one more time, then I dare you, because no, so marami daw baba kayong tanaw sa patent clerk, no, but then course, it revolutionized the way technologies progressed today, with the help of these patent clerks. So remember that na si Papa or Lolo Albert was once in the patent office. All right. So today, tungod mo ng mga karano, many industrial property offices accumulate and categorize patent information in patent databases that are searchable, published, and updated on the internet. So today we'll be looking at the different patent databases. My colleagues will introduce you to those other online databases. And there are free patent databases, and there are also premium databases that kind of you subscribe every year for specific amount of money. So just an overview, what are these patent office that we have in the world today. These are the most popular one, the World Intellectual Property Organization. They have their own patent databases for free. So you can log into PatentScope. You can find documents there. And then you can go also to ISPASnet. So this is from the European patent office. So we know there are a lot of countries in Europe, so they have a centralized system in terms of for filing patent application. And then the US Patent Office concerning all patent applications in the US, Japan Patent Office, and of course we have our very own Intellectual Property Office of the Philippines. But you can also find documents, patent information on journal articles. So we have magazines as well, and basically other database. So for example, I mentioned about Google. So Google is also a good source of patent information. So basically, you can kind of, because of the algorithm that they develop, you can also find documents there as I don't know, as fast as like other database. But usually kami, because of the amount of like information built or registered or applied in the European Patent Office, so we kind of use both the WIPO and ISPASnet, na patent database. There is also this paid na I mentioned about paid databases, Thomson Reuters. Okay, so what is the value of patent information? Okay, so these are some of the things now that really why we need to do patent search prior to the R&D. So I think the number one here that we'd always go back and tell students and researchers to conduct patent search so that we don't really duplicate those already existing in the databases or in the available already in the market. So that's why we need to conduct patent search. So to avoid duplication. So databases have up-to-date information. Up-to-date information, like every time you have patent documents applied, and then they are published, so they are immediately uploaded to the systems. That's why if you want to know about the technology trends, you can look and go to the patent databases and see for yourself what is happening in that particular area. Like for your case, guys, na into agricultural machineries, so you can use patent databases to determine, for example, what are the technology trends in terms of the rice thresher, for example, rice thresher, So you can look at the patent document and then search for rice thresher. Now, with regards to the how to do it, so these are the things that will be discussed by Kenneth and Lawrence in a while. So there are some techniques, procedures how to do it effectively, to narrow down the scope of our search. Okay, so cost of insufficient patent information search. So every time there's an R&D, so we do patent search mainly because we don't want to repeat once again the technology that was already created and already been registered for or applied for patent. So do you know that every year the European Patent Office, based on their study, they noticed that some of the R&D or many R&D companies spend around more than 20 billion euros every year going to waste because they spend on R&D and then not doing a lot of patent search, and the technologies actually that they're also trying to do or develop is already there in the market or is already been applied with patent. No, so there's this related cost. No, so we are trying to avoid not only duplicating it but trying to invest money, no, to invest or use money to do the same thing. No, in fact, that this is already a existing technology. No, so that's the reason why. So I think for us in the university, we need to be also like aware of that. No, your proposal right now in the ABE, in your research methods proposal, labi na wala pa siya ninyo gi-develop good, you really look into the patent database or really conduct a prior art search, no, para makita gid ninyo nga this is not yet existing, because if it's already existing then you're just wasting your time, no. And then yeah, so I remember me and some of the guys, my fellow ECE students, I always tell the story because this is really true and then this happened. So we try to think about how to innovate the water dispenser, no? Because the problem we look at, especially me, I arrived at home and I saw my father before using the water dispenser nga wala na tubig, and then he's a 70-year-old man, he carried this pila na 6 gallon ng tubig, no, and then he lifted it up and then murag murag sa katigulang na murag di na gid kadaog, no, and then no. So I saw that opportunity to think about, well, try to develop kung unsay machine nga pwede i-replace, pwede ba siya sa ubos na lang and i-pump out ang tubig and then you can make that as a dispenser, no, so you don't have to carry the bottle anymore. So kami mga ECE student, ECE nga professor, we spend some time brainstorming kuno Jaime, nag-design, nagimo na mig-design. So nagimo na mig-design, no? And then later on we said that before we develop this, maybe we need to look around kasi existing na siya. And through matter of fact, we actually saw that already, that kind of technology nga dili na mo kinalalasahon ang tubig, no, para sa water dispenser. Nakita na mo siya basically na siya sa market. So with that, we avoided doing the same R&D supposedly maunta to may develop, no, because there is a potential market. So we thought about, well, if we can develop this kind of product na people will not carry the water bottle anymore, ilan na ipo sa ubos, so there will be market for that, no, for sure. So basically what we did was discovered it na okay, it's not anymore possible, no, because it is already existing in the market. So we avoided the R&D cost, we avoided the duplication, and we disbanded that idea. So the other thing, I think, if beyond that state, no, so pwede po ninyo i-improve, no, so unsa pa may wala, so meaning to say you look into unsa pa may pwede na to ma-improve, no, such that it will be still novel and inventive at the same time, no. So we discussed yesterday about those 3 requirements. Okay, right, use of patent information for the corporate strategy. So basically, when Apple applied for their first smartphone, so basically the information related to the patent is indicated in the patent document, no? So unsa day sulod ana, no? So basically when you look at the patent document of the smartphone, so everything is revealed there, no? So muna siya gibungkag, and then the patent agent would discuss about what is inside the smartphone, no? So when you are a company that sees an opportunity on that, so the tendency of these companies is to look into that patent document and see on what area can they still work around, no, to develop the same product, but being careful about not infringing, no, so not violating any rights of the IP of the originator of the technology. Now, so this can be the case of for the companies now out there. So pwede siya. So sa to gyapon, mao gyapon na sa to, pwede gyapon na to. We can do that. Right. All right, so these are the objectives of patent search. So I have 20 minutes. So one, again, avoid duplication of R&D work. Now, identify specific new ideas and technical solutions, products, or processes. Okay. So if you go to the patent databases or conduct information search, then you'll see different technical solutions, no, innovative solutions that you will not get from the university. No, so it's just by looking at those patent documents. So you can identify the state of the art, the frontier of knowledge in specific technological field in order to be aware of the latest development. So basically, as I mentioned earlier, that's where you get the information, no? So the latest trends, because companies, kani mga dagko nga companies out there, they don't reveal the technology unless if they applied for patent. So I think yesterday this was discussed, no, that companies actually filed patent first, no, before declaring that they have this product already. Before, ang US market, ang US nga country, no, so they have this, you can open it, you can open the technology to the people, but you can file for patent within the year, no. But now they are also in the process of, you need to file your patent first, now before you disclose the invention to the public. So sa una kanang first gig nga iPhone, smartphone, no, si Steve Jobs, yan na nang declare, no, nga we have a very cool new product, the smartphone, before they actually filed for patent. But now they filed patent first before declaring to the public. And basically you find those updated na technologies and features of the phone. So we have here identify alternate technology and its sources. So more and more, if you want to study about smartphones, so you kind of dig deeper, know what kind of technologies out there in the smartphones. No? So you'll get plenty of documents to base from, and then you screen those documents, and then you can kind of having an idea now na dapat siguro these are the things that I can still improve from these technologies presently. No? So yun na siya. So going back to the water dispenser, maupod to, no? So unsa man day karon ang mga technology development sa dispenser, and how can I further innovate on the water dispenser? In the same manner, in the rice thresher, what are the technologies presently in the rice thresher? And then you base your innovations from there on. So parang that is your parang stage, no? Parang that's where you leapfrog from in terms of developing a better technology from the existing technologies out there. Okay. So identify existing or prospective industrial property rights, the validity, ownership. So like you'll find documents that would have like expiration date. No? So they have this validity until 2021, just like the case of Beer Brella. That will expire by 2021 in October. And so basically by looking at that, that means that you're free now to kind of so adapt that technology. If you're interested in sell it in the Philippine market, there's no problem. Actually, even if now, no, if you see that patent sa Beer Barella and it's not applied in the Philippines, by looking at the patent database of the Philippines, if it's not applied here, you can freely sell that, no, copy and sell that. So basically that's the idea. So you can actually start a business now by looking at just patent documents out there, which are not applied in the Philippines but were in the US, and then do it here. No, for example, ang kanang Uber na mobile phones, no, dagang kayo example, Uber na application, mobile application, they applied that really in the US. No, so I think Europe as well, but I think they did not apply here in Asia. That's why Grab has the same technology, actually, the same mobile applications, and they were able to gain that market share here, because they were not since Uber doesn't have a patent here, so they were not like prevented by the state, or by Uber to use these mobile applications. Okay, so another one is assess novelty and patentability. So these are the major reasons why the objectives why we conduct patent search. Right. So patent information search can be used as here is a case study in India. No? So I'll just go through this. So generic drug manufacturers in 1990 in India emerged as leading suppliers of generic drugs to developing countries, and how they accomplished this is not so well known. So this is a case study, no, but worth reviewing here. Basically, pharma companies, manufacturers in India made the best use of the patent system to develop their knowledge and capacity by studying patents. And how did it serve as a good lesson to other developing countries who have not fully used the advantage of the patents? Basically, the story is there. So the story here in summary is that the Indian pharmaceutical companies actually studied patent documents out there, no, in Europe, in the US, and then they were able to like recreate those medicines. No, so through the patent documents, recreate the medicines, for example, sakit sa ulo, ubo, hilanat, no, so they were able to recreate that, and then they produced that cheaper. Why? Because they don't have these to go through these experimental experiments. You know, pharmaceutical companies invest or spend a lot of money in terms of producing or in terms of R&D, no, the drugs or the medicines in Europe or in the US, like Pfizer, Moderna, we have right now, AstraZeneca, Sanofi. So I'm familiar with this because my wife is into the medical practice. So these big companies really use a lot of time R&D and they spend a lot of money, no? So in terms of R&D, and spend a lot of years, no? How many years they would have to develop the medicines before it's really been approved by the FDA, no? And then they can only sell that when they get approval. So it's very expensive process. That's why our medicines also out there in the market today, also here in the Philippines, are very expensive. That's mainly the reason, because the R&D cost is very, very high. So that's what's happened in India. So they were able to recreate that and sell, no, because of the patent documents available, and recreate those medicines. And then they did not spend on the R&D because the results of the R&D are already available. And so they were able to sell these medicines at a cheaper prices. Okay. In the Philippines, this is true as well, no? Unilab. Unilab yan, no? So you're familiar with Unilab yan? No? So Unilab yan. So this is the biggest drug lords, drug lords, the biggest pharmaceutical company in the Philippines, no? Unilab. So they earn billions of pesos every year in net margin, to tell you honestly. So they don't have R&D facility. Again, because of my wife, no, in the medical field, I was able to like listen to those guys in the Unilab, went to their factory. They don't have R&D. They don't spend a lot of money in terms of R&D. What they did, they did this. I think they've done the same thing. No, what India has done based on the case study that we presented. No, so basically that's what Unilab really used, no, to look into the patent documents as well. No, so and they were able to develop these medicines on, well, sipon, flu, so bioflu, Unilab yan, no? So Unilab yan. All right? So those are basically documents that they found, no? And then basically sakit sa ulo ng mga tambal, no? That is like pila naman nakatuig, no? So ang patent, di ba, 20 years lang ang protection. So that means that yeah, the expired patents, they were able to capitalize on that, make use of that, no? So ako lang na ipakita, no? So appeal ko doon sa picture, but focus on the guy on the right, no? So this is Attorney Jose Maria Ochave, and he was one of our speakers in the SciTech for Dev in 2018. So we really invited him. We got access of him. This is a very busy guy, but we were able to really get him, and he was able to come here in Butuan City and be our guest in the University Industry Government Forum. This was his first time to join in any academic event, no? And then he has a very high rank, and yeah, because of my wife's help and mga medrep, no? So we were able to tap him because of that. And this guy is a lawyer, a graduate of Pisay, and he's very knowledgeable in patents, no? So alam niya lahat. And then actually during the conversation here in the forum, the first university industry government forum that we organized in the office. No, so he knows everything about what's, so this guy is really available. Like, he told a story about the growth of Unilab, how they go from a very small company to how they were able to become very big right now. And basically, they use those patent documents now, and even advise researchers, no, first just copy what they have in the patent document, and then later on improve from that. Not so basically that's the bottom line he mentioned. So yeah, this guy is awesome. No, I can say it is awesome. And then right now, he's like moving around different universities now because he saw the potential. And after this meeting, they met with my Ma'am Jinky Bernales, and yeah, so because MSUIT is a very strong in terms of the R&D of related to health, no, kanang mga traditional medicines. So they kind of have this agreement as well with MSUIT. So this guy is amazing, believe ko. Now, I have 10 minutes on my clock. So types of patent search. So, so we have 8. No? So these are the last thing that I want to discuss. So 10 minutes time. So pre-application search, state-of-the-art search, novelty search, patentability and validity searches, name searches, technology activity searches, then infringement searches, and legal status searches. So I'll try to go through with these types of patent search. So pre-application search, we know that the patent application process is time-consuming and expensive. I mentioned yesterday that if it's not for it, so CSU will be paying like 100,000, over 100,000 pesos every patent application. No, so that's very expensive. So because of this, you guys, the students, the researchers, are actually asked or required to kind of conduct the pre-application search, no, before filing for a patent application. So unsa man na siya, no? So kaning pre-application search, so basically you just look into the printed publications, no, public knowledge. So katong gi-mention nato mga journal articles, no, mga documents that are already available, no? So basically you can do that, no? So just like the example I have earlier about the water dispenser. So what they did was search Google, and then even we saw those we saw that kind of water dispenser nga naa na siya sa Lazada gibaligya, no, for example. So you can freely look at that, no. That was what we did, pre-application search. So basically we did not even go to the patent database yet, no. So we just want to know if this is already available in the market today. So that's what we did, no? So after that process, the pre-application search, you might want to go proceed to the state-of-the-art and novelty searches. If you think that you did not even find a single document that is related to the idea or the idea or the technology that you are trying to pursue. Okay. So state-of-the-art search, this kind of search is also referred as information search or informative search. So state-of-the-art searches are especially useful for technology development or technology transfer purposes. So it is performed to determine the general state of the art, so the current technology or method to find a solution to a given technical problem as a background information for R&D activities, and in order to know what patent publications already exist in the field of technology research. In summary, so just thinking about what I mentioned about what is the state of the art of the water dispenser right now, no, and then look at those things, and then that's where you kind of helped out. Okay, wala pa din, no, in terms of the technology direction, no? So that is considered as part of the state of the art search. Novelty search, so kani siya may pinaka highlight, no, because now you're trying to determine whether your idea is actually new or not. So the aim is to discover relevant prior art or if patent has already been granted, no, so similar to your technology. So you go for novelty search. So novelty, the other term for novelty, diba, new. So very obvious, though. Okay, I have 6 minutes left, so I will not just thoroughly discuss this. Basically, what you want to do is that check the database now, patent databases now, if there are existing technologies that are related to your invention. And if you need to find the closest prior art, kumbaga, no, the closest technology or patent document that is related to your technology, because sometimes you will not be able to find one, but what you do is find the closest prior art, no, to your especially that refers to novelty aspect. Okay. Okay. So the outcome of the novelty search will help you with the next decision, whether to go forward, spending time and money developing the invention. So this is the go, no go decision. So basically, the office like conducts patent search. That's why you guys, supposedly this is a one-day webinar, no, because we need to have like an exercise. So right now, I do believe that with your research methods and subject, you have an idea already, no? You have a project proposal already. And you need to conduct a patent search and then determine if it's novel or not. Because if it's not novel anymore, as I've said mentioned earlier, no, I've said that we don't have to go further with this, no, if it's already existing. Or your option would be to improve the idea or to improve the technology that it may consider be as novel. No, unsaon na siya nga para mahimong novel. So that's where go, no go decision is. Okay. So if there are several patent documents, so the decision is more difficult if one or several patent documents are found. So actually, this is one of our major problems in the MapX. No, kaning MapX nga ginakuan karon ni Dr. Rolin Dagil. So many relevant patent documents, and that's where the decision, it's very difficult nga, it's really impossible because you always defeat the part wherein not only just the novelty but also the inventive part. So that's the most challenging part. So after the novelty search, you have number 4 here, the patentability and validity search. So of course, earlier we have the novelty. This one here is focusing on whether to determine and find out that we will qualify in terms of the inventive aspect. No? So I think this was also discussed yesterday by Lawrence, no? So Engineer Lawrence Grana, in terms of the requirement, no, patentability requirement. So sa ganito, so I have limited time na. So patentability requirements of me as technical solution on the problem, it should be novel, and then the other requirement is the inventive step, no, then industrial application. So usually in patent application, kani gyud ang pinakalisod isudlan permanente, no, qualify or masaran, no, inventive step. So we find documents to know, no, if we are not able to pass the novelty and the inventive aspect of the patent documents. So I think Engineer Grana has presented a very good case yesterday about how to make your invention, what is patentable or not, no, based on these two requirements. So basically, these novelty and patentability searches, they are commonly carried out by the patent office, no, sa IPOFIL. No, but yeah, to determine, to really put a like make a decision later on whether to grant a patent or not to your application. But supposedly for us, no, so technology generators, we also do the same thing. So we go through this process, no, so pass. So if you want, okay na ka sa pass, and then you proceed with the novelty and patentability searches. No, so that's where like dinagit medyo very challenging. No? So, but then if you're able to cross this, good for you. So we want you guys research methods. Hopefully you can conduct. No, so if you have time for more exercises, no, kanang pagidonta workshop. The decision was to just discuss this patent search today. But we're just really hoping that you guys will be able not to conduct really your own patent search and develop your own patent search report so that you have all the confidence that your technology that you are trying to develop is novel and inventive. So name search, search is often used for locating information about published patent documents involving specific companies or individuals as applicants, assignees, patentees, or inventors. So you can find, no, in the patent database, you say, okay, sa CSU, pila ka patent application na ng CSU. So you can use that, no, or the big companies like the IBM, kinsa pa man, mga, so you can go, no, Apple, Samsung, like the Google, pila na kabuok ang patent approved sa Google, no? So you can use the patent database. So, and then technology activity searches, for example, in the field of this water dispenser, who are active in this area? No? So who are active in this area? In the smartphones, which companies are very active here? Which companies have like a lot of number of patent right? So technology activity searches. Okay, we're almost there. So infringement search. So kaniwid, no, kung legal ba ka, no? So locate patents and publish patent application. So we need to think like maka-infringe ka ata, no, with our patent applications right now, maka-infringe ba ka ata sa uban nga applications. So mura bitaw related to the freedom to operate, no? So that means that all right. So maka-infringe pa ta sa lain, no, kung kani atong kind of claims nga gi-propose, and then if we market this product now in the market, maka-infringe pa ta sa katong mga product that are existing already in the country and granted with patents. So there will be cases later on, no? So just like what I mentioned about the Samsung and Apple story, no, that the infringement caused by Samsung, they were required to pay Apple. No? So that was the story we have yesterday. Okay. So in this type of research, the aim is to determine whether an existing patent gives exclusive rights covering that industrial activity or any part of it in a particular country or region. So basically, no, kung madto kag laing countries, then you have that patent, so maka-infringe pa ka dito. That means you have to carry out this infringement, no, na search. Okay, legal state. This type of investigation is made to obtain information on the validity of a patent or published patent application on a given date under applicable patent legislation in one or more countries. Okay, so I think we've covered the important types of search. No? So again, for me, we advise you to perform first pass and then the novelty and then the inventive. No, kaning mga legal, you can actually do this later on. So the important thing is that we can develop a novel and inventive na mga machines, no, if you are trying to design machines. So novelty and inventive, no. So validity search, patentability, and yeah. So these are the most important types of searches that we have. All right. So I think it's already 2:30. So that's where my presentation ends. So thank you again for your time and for listening. No? So I hope you've learned something new today. All right. Thank you guys for listening.
Thank you, sir.
All right. Thank you so much, Engineer Jeffrey. Thank you so much, sir. We will not be tired saying thank you, sir, because we are really grateful for being one of our resource speakers for today, sir. Thank you so much, sir.
Thank you.
And we hope to see you soon.
Thank you, Kenneth. I'll just ask permission because I have a meeting with Atop, and then Sir Kenneth here, and then Lawrence is already here. So I'll just pass on the hosting to Sir Kenneth, and yeah. So I thank you guys. No, so I don't know how long our meeting will be, but yeah. So I wish you also good luck. Thank you. Thank you, guys.
Yes, thank you so much, sir. We understand, sir. We can continue, sir, if you're back, sir, for the Q&A and also for the presentation of your certificate, sir.
All right.
Thank you so much once again, sir. And have a nice day, sir.
Thank you.
So how are you, everyone? I hope that you're still there. So keep on hanging, guys, because we're going to proceed now for next part of our program. program. So are you ready, sir? Because our resource speakers are really prepared for their topics, and we hope that you will bear with us along this presentation. So I guess that we are all ready. So I guess that we are all ready to our participants and speak for our next speakers. Um, Let me know, sir, if ready na, sir.
I'm still waiting to become the host of the Zoom.
Yes. May I request Ate Shiva if pwede ma-change.
Sir Jeff, I think Sir Jeff has the power to do so.
So,
Sir Jeffrey, can you upgrade my role as host?
Hello, Ken. Ken.
Yes, sir.
Yeah, so I made you a co-host, and then
Okay.
I'm already recording. I'm just afraid that if I made you a host pala, the
Yes,
recording
sir.
will stop. No, so yeah, so you can try if you can screen share now.
Yes, sir. Yes, sir. Thank you. Thank you.
All right, thank you.
So I think we are ready to start for the next part of the program. So I believe that you all know about for our next speaker, and allow me, guys, to welcome him again for the next part of the program and the second session for this webinar series. Help me welcome again Professor Kenneth Ciudad. Thank you, everyone, and I hope that you will bear with us. So happy listening. So welcome, sir. Welcome, sir.
Okay. Am I going to start now?
Yes, sir. Thank you so much, sir.
Say good afternoon once again, everyone. Yulubon, Yulubon. Uh, so basically, I'm very thankful to Sir Jeff because he covered most of the introductory part that I'll be giving this afternoon. So that gives me, the opportunity to just be faster in my discussion today. So are you seeing now my slides?
Yes, sir.
Yes,
Okay.
sir.
So my, of course, my topic is on patent search tools. So it's very specific. So it's going to be short. So to begin, this allow me to show to you the basic, or rather the common steps for doing the patent search. So usually you have this, no? You have to learn to describe the invention, determine the initial classification, and consider relevant keywords, and so on and so forth. And this topic that I'll be giving to you is basically focused on uh, determining the keywords. So in this part, so my topic will just focus on this part of the steps, no, of the several steps in the patent search, the entire patent search process. So another disclaimer, most of the slides and content are taken from the talks or the presentations from Engineer Marcon Zabala of IPOFIL, as well as Engineer Walfredo Calaguan, who is also of from IPOFIL, who is now actually the officer in charge in a certain office or bureau, no office, just office in IPOFIL. So okay, let's start. So I think I know I'll just be capturing some of important, no, I think everything is important as discussed by Sir Jeff, but I just captured few which I think which are very relevant to this talk. So when we talk about patent search, we have heard it. It involves searching different databases to see if the idea has already been patented, to know if the idea is also if our idea is patentable or not. So the results of a good patent search should reveal any identical, similar, or partially similar invention. So take note that the statement being used here, the word being used here is idea, because basically what is a good practice is to conduct first a patent search before you engage in developing a technology. No, once it's just an idea in your mind, conduct a patent search already. Do not wait that like just commonly what is happening nowadays. What we do is someone has already developed a technology and then conduct a patent search. So what happened is later on we realized na the technology that has been developed recently has already been created, no, has been existing already a long time ago. So that's very unfortunate. So it's a waste of money, an effort. So that's why patent search should be really conducted even before or when it's still an idea. No, it's not yet developed. So I think this has been established already. So I'll just highlight some of the importance of why do we need to do this. So avoid duplicating research. I mentioned that, no, to determine if your idea is patentable, to avoid infringing, and of course, as mentioned, IPRs are business strategies. No, it's a business strategy that you have to when you find potential in your work, then it's your strategy whether you are even the decision making of which IPR you're going to apply is also a strategy. So everything is a business strategy. So when you do patent search, it's a good tool, for you to determine or to guide you in your business decision. Also, in the search, you would be able to learn a lot about the details about the technology itself, no? Who are the companies um, producing the same? Which country are these most likely, or this is mostly widespread? So it's a business decision. So it's very helpful. And of course, identify key trends in specific technical fields. So especially, like yung naisip mo ay obsolete na pala. So at least you would know kasi you will be able, when you do the patent search, you will be able to also the patent family, like everything related to the technology. So you can learn what are those related technologies, that can they're called patent family. So you could trace back, from the earliest technology to the latest. So you can also see the trend and assess somehow your idea, which part am I? Baka nasa obsolete ako nga part, or high tech pala, or wala pang nakaisip. So this is very helpful. So prior art, we need to understand this. No, this is very important. I think Sir Jeff has also emphasized this. Prior art is everything that has been made available to the public anywhere in the world. So I think someone has asked this relating to trademark. So it's I mentioned this also yesterday that there is also a prior art search conducted for patents. So the same with trademark. So if you apply for a protection in this country, so the patent examiner will conduct a search, prior art search for that, and check on the database all around the world, or all applications around the world will be checked whether the technology that you're applying for is already existing or not. Or in other words, if the technology that you're applying for has been made available already to the public anywhere in the world. So that's how important prior art search is. So generally expected to provide, description sufficient to inform an average worker in the field, or yung tinawag ni Sir Lawrence kahapon na person skilled in the art. So ayun, what is considered also prior art if there is a substantial disclosure, no? Substantial disclosure, because sometimes technology are disclosed, but it's not sufficient enough that anyone who is skilled in the art, or have a common knowledge about the technology, can replicate right away by through that disclosure. So sometimes the disclosure might not be that substantial. So it's okay. It's not considered a prior art if it's not that substantial. So patent information is available from both free and free-based sources. So okay, so where can we find this? So what are the different forms of disclosure? So we need to be careful pala, because anything that is disclosed can become a prior art. Again, substantially disclosed. So examples, written description of the technology in books, in magazines, whatever, written description. Even oral description, like you disclose to someone, or in a forum, you discuss in a webinar, you discuss the details of your technology substantially, that anyone who hears your talk can actually be able to replicate your work. So that's already considered a prior art. So be careful, in disclosing your work. So especially for you, especially when you have when you defend your thesis. So make sure that you have the OGN signed a non-disclosure agreement or a confidentiality agreement. That's very important, especially when you are confident that your technology is potential for patent. So make sure that when you present your work, your audience are under an agreement na they will not disclose to everyone else, no? What is in that room should stay in that room. So parang ganon. Another, by use. This is also crucial, because a lot of our inventors, local inventors, they do not. Yes, MMJ. I can hear the chicks. Oh, yun. Thank you. Okay. So a lot of our local inventors would right away introduce their machine. Masyadong excited. They allow their friends to use it or even reproduce it without even applying for patent first. So later on, when you apply for a patent, and the examiner will discover that your product has already been used in the market, or used somewhere else, then it can be detrimental on your part, because it will be considered a prior art, or any other way. So there are many other way of disclosing, no? So ayun, be careful tayo, guys, ha. So these are disclosures done before the filing date of application. So ayun, prior art. So there are free sources of patent information, and so these are other forms, no, perhaps of disclosing in newspapers, journals, radio, the internet, information database, company publications, official publications by government authorities, such as reports, statistics, etc. So again, don't be also too strict na pod, na parang you don't want your work to be featured somewhere, because you are afraid of your work be considered a prior art. Again, we have a qualifying word there, di ba? It can become a prior art if there is a substantial disclosure. What is substantial disclosure? Yung disclose mo yung technology mo really in detail, in such a way that, again, a person skilled in the art can easily follow, can easily replicate your work. So in patent database, there are free and there are also commercial. So you'll see a few differences. Now, obviously, commercial are more updated um, database compared to the free ones. Though free databases are sufficient enough, in conducting patent search. Okay, let me give you some examples. Here are free patent database that we'll be introducing to you. So we have the WIPO, the EPO, ISPASnet, the USPTO, the Japan GPO, the IPOFIL. This is the Philippines version, the PhilPat. So ayan, here are some of the website where you can actually find those free online databases. And for WIPO, for USPTO, anyway, I'll be giving show to you their interfaces. So at least you could be familiarized. Because in this webinar, we'll not be doing a workshop. We have no luxury of time to do so, no, kasi we understand that most of you are just using cell phones, so you don't have a multiple screen or windows, so you can't listen and do the workshop at the same time. So we will just introduce to you um, all information that we think are necessary. Okay. So there are also commercial databases, of course, kasi commercial, may bayad siya. So what we are using in the university is the Thomson Reuters. No? So yeah, that's the subscription we have. I forgot how much we paid. Sir Lawrence, you remember? Sir Gana?
Yes, sir. Around 60K. That's
60,000?
60,000.
But that's discounted, di
That
ba?
is the discounted
Oh,
for
discounted.
ITSO offices.
Yeah. Because we are parang an affiliate of WIPO, no? Through ITSO. So basically that's around 100 plus, di ba? 160 if I'm not mistaken. So I think something like that. So it's very expensive, no? Anyway, business kasi. But again, the free databases that will be, thank you, Sir Lawrence, the free databases that will be giving to you are sufficient. So don't worry. So also, Sir Jeffrey have already mentioned this. What can we find in the patent information? So here you see patent document, reference numbers, applicants or inventors' names, keywords, patent classification, application number, publication number. So many, a lot of details, no, that you will get from a single patent document, actually, no. So you'll find all of these important informations, relevant informations. So okay, also the inventor's name. But take note that some applicant may use different versions of their name, no? So syempre, depende yan kasi sa pag-apply. So sometimes they use the acronym of their company if it's a company, or sometimes they use the name of itself of the owner of the company. So it may vary, no? So depending. So this is an important thing to note, especially when you use the applicant's name or inventor's name in your search. But anyhow, again, as I mentioned, among the important search criteria that are available in this talk will focus on keywords, on how do we go about using keywords to help us in our patent search. And in the next topic, I think Sir Engineer Grana will discuss on the patent classification. So keywords. So these are words or phrases which describe essential technical features of the invention. So keywords can be searched in the title, abstract, description, or claims. So don't forget or remember, search for synonyms because different country, different inventor, different scientist might be using, different terms. So you have to be careful also. You need to we have to be um, inclusive in our choice of words. So one example here, yun, may nagamit ng plow, but the spelling for others is ayan, iba, no? Ploughh, while in US they just simply use the PLOW. So yun, language differences. So ayun, different standards kasi, di ba? And ayun, you'll find that it's an English version, meaning it's a translated version of the document. Actually, there are choices in the language. EN, no, stands for English, and sometimes the translation might be different from one database to another. So, how do we limit our keywords? So, sometimes kasi when we use keywords, a certain word, um, parang, and you notice that I don't know where was it mentioned. Sometimes kasi when you use a word and as long as the word the system will find it existing in a certain document or in various documents. So all of those related documents will be given to you, no, by the database. Nga, okay, when you search a certain word, then it will give you those numbers of patent documents, and that's a lot. So it's difficult to pinpoint which document that is really closest to your idea or to your invention. So that's why we make use of this one, the truncation or word stemming. So, for example, uses wildcard characters such as asterisk or question mark to substitute for any other character or characters when added next to a string of sources. This one is used to also be inclusive rather, no, because in our patent search, actually at first, we want to be broad as possible so we can capture all possible existing documents relating or very related to what we are searching for. So that's why we use this truncation. So example, attach asterisk. That means it will capture all other suffix, no, or words or letters after attach. So it will include attached, attaching, something like that, attachment. So it will broaden somehow your search. Then if you put it as a prefix, then reattach or something like that. So when in both, then reattaching, reattach, something like that. And for example, we know that there are Oxford, diba, standard, and we have Cambridge. So especially in America and UK, they use S and Z, diba, interchangeably. Like for example, I think Z is used by the US and S is used by the UK standard. So you have to, like when you just use specialization, so you will not be able to capture documents translated or coming from the other side, no, from the UK. So something like that. So that's truncation. Then we have phrase searching using quotation marks. So this one is also important to limit because if you just independently, and I'm saying independently because like when you type electrical and conductor, it will search all words relating to electrical and also separately uh, about conductor. So everything about electrical, whether they are, right next to each other or not, it will be included. So that's quite broad also, no? So we don't want, as long as, especially when you are confident that the term that is used really is that they should go right next to each other, the electrical and conductor. So you use the quotation mark so that you will only capture uh, patent documents containing the word or the phrase electrical conductor. So I think this is also applicable in Google search, our common Google search, diba? So we use this. So we have Boolean operators. These are used to join words or concepts with defined true or false operators such as and or not, XOR or near. So let's see what do this pertain to. So for example, we have uh, two sets here. No, we have the left circle and the right circle, and there is a there are parts between the two where they are mixed, no, together. So for example, on the left side, these are pertaining to all about cars and all about cars, and on the right side, all about airplanes, so separately, independently. So if there are, sometimes there are matters that involve both the cars and planes, something like that. So what are the Boolean operators that we're going to use to describe this different sets? So for example, when we use or, car or plane, so that means everything all about either independently about cars, independently about airplanes, or the mixture of the two. Brad, mali yung word doon, mixture, kasi chemist kasi ako. So meaning combination of the two. So we have a combination of car or and plane. So it involves everything about it. So that's one thing, no? So if that's what you are searching for, no, you don't care because it's part of what you are looking for. So you use the Boolean operator or. So yun, results, anything that is car or an airplane or searches are inclusive and return many results. Yun, marami. It will capture everything. Now when you use and, so it will now exclude car only and airplane only because you use the word and. So what it will capture are things only that are both cars and airplanes. Gets ba? Very easy to follow naman, di ba? So the resulting search thread that you can get here are only both cars and airplanes. Exclusive. So you have now a narrower results. So you will only get everything about both and not either. So when you use not, so this will now exclude the other. So here you use the word car, not airplane. So it will only include car that is not related, in any way related to airplane. So something like that. So cars, but not cars, which are airplanes or related to airplane. Not searches are exclusive and will narrow your results. So by that, you have now a limited number also of, especially, kasi alam mo car lang talagang hinahanap mo not related to airplane. So you can now easily go through the number of documents that you can get from the database. So near operator. So documents having both the words car and airplane within a certain number of words of each other. So in other words, parang may proximity yung dalawa. So near si car, dapat malapit lang. It's not na-mention lang sa abstract si car, tapos hindi naman na-mention doon si airplane. So that will not be included. So you limit your search. So that's how important it is. So useful when searching variation on phrases containing two terms. Example, airplane with engine of car. So you see, they even belong to the same phrase or sentence. So parang hindi magkalayo. Pero that does not necessarily mean that airplane and car are right next to each other. Hindi naman ganun. Because in that case, you can use the quotation mark. Okay, I hope you're still able to follow, ha? I'm trying to be faster in my presentation. So we can also use parentheses or nesting to clarify order, search, or query. So these are, another example. So will and tapos nested si steel or alloy. So what it will search lang. So again, wheel and steel or wheel and alloy. So something like that. So either of the two is either steel or alloy, not wheel and steel or alloy. So it will give you different set. No. So using parentheses is a way of forcing the order of processing of logical expressions. So has great impact on the search results. So here is the summary of the different Boolean operators that you can use for different free uh, free patent databases. No, so above here in the matrix are the databases available: Patent Scope, ISPASNet, USPTO, the GPO, and what's this one? Fill, yeah, the IPO the fill path. So these are the strings used by these patent databases. Okay, so this is what you can see. This is the interface of the patent scope nowadays. Because they have been actually upgrading also. So far, this is what I've found last night. So this is very fresh. So if you type in the wipo.int/patent scope, so it will direct you to this interface. Then when you click the access the patent scope database, so it will give you this one. So you have now your simple search. Then here, if you click on this one, you'll actually have different choices. So either are you only looking at the front page, any field, so meaning any parts, the one that I have enumerated a while ago, no, any parts of the patent document, or full text, ID number, specific pa siya, ayun, it will search only according to what you will set here. So that's simple search. So parang ano siya, parang automatic to. Yan. And by the way, okay. So anyway, so yun, example lang naman to ha. You can explore further on your own when you have the time to visit this database. So I just to give you an example. So I make use of the phrase cacao pod crusher because this is just an example. This is not, I'm not claiming this is the best example. This is the perfect example, but this is just an example I thought of because this is related to our ongoing project on cacao. So I typed here cacao pod crusher, for example. And by typing in, I think I choose the any field here. So it gave me, so this time very swerte, or maybe it means something, no? 20 lang ang results. Yun, cacao pod, and there are only 20. So it's either the inventors or the applicants are not using cacao, or maybe they're not using pod, or maybe they are using different terms aside from crusher. So it could mean like that. That's why I only have 20 results for this case. So yun. But usually when you use a more commonly used term, it will give you, hits of more than thousands. So it will be difficult to go through each document. So kasi ito, here, itong mga title na to, these are already links to the patent document. So individual, no? When you click on that, it will give you the details about the patent, this patent. So it will give you the document even downloadable, and it's free. So what did I do here? So when you click on this part here, the search,